Welcome to CADRE's companion video to the IDEA Special Education Written State Complaints Parent Guide. When you have concerns that your child's school has not followed the requirements of the Individuals with Disabilities Education Act, IDEA, and want to request an investigation, filing a written state complaint might be an appropriate dispute resolution option. This video explains what a written state complaint is, considerations for this option, and how you may file a complaint. Written state complaints are described generally for Part B of the IDEA. This resource is not intended to interpret, modify, or replace any procedural safeguards or requirements of federal or state law. A written state complaint is used to communicate that a public agency, such as your child's school, has not followed the requirements of the IDEA, and to request the state education agency investigate the problem and make a decision about the complaint. Complaints may concern one child or student or a group of students. A few examples of when a parent might file a written state complaint include: you disagree with the decision regarding your child's eligibility for special education and related services. You believe the school is not providing the services included in your child's Individualized Education Program, IEP. When you are considering filing a written state complaint, it is helpful to know that this process is the only IDEA dispute resolution option available to any person or organization, including people who are unrelated to the child or students that the complaint concerns. Also, the outcome of the written state complaint is a final decision, which must include actions that are required to address the needs of the child or group of children involved in the complaint. Another consideration is that you do not need to hire an attorney or advocate to file a written state complaint. Before you file a complaint, however, you may find it helpful to talk with someone who knows about the process, such as a Parent Center staff member. Any person or organization, including one from another state, may file a written state complaint. Written state complaints must include certain details to be considered complete, including a statement that a public agency has not followed a requirement of the IDEA, facts that support this statement, and the signature and contact information for the person or organization filing the complaint. If the complaint concerns a specific child, this information must also be included: the child's name and address, or contact information for a homeless child, the name of the child's school, a description of the problem, including facts relating to the problem, and suggestions on how to solve the problem. Written state complaints are usually sent to the state education agency. A copy must be sent to the public agency in the complaint at the same time. Your state education agency must make a written state complaint form available, but you do not have to use it. Looking at the form and seeing what information it requests may help you organize your thoughts before writing a complaint. A complaint that is received without the required content may be dismissed or returned, which could delay resolution of the issues. It is often helpful to include information and copies of evidence that support your claim that a public agency has not followed the requirements of the IDEA. Evidence may include IEPs, letters, notes, and reports. After you file a written state complaint, you should be given an opportunity to provide additional information that relates to your complaint, either verbally or in writing. It is not unusual for someone to contact the people involved, including you, to gather information needed to resolve the problems identified in your complaint. The issues in your written state complaint must not have occurred more than 1 year before filing, unless your state provides a longer time period. You may wonder if you can still file a written state complaint on an issue that was previously decided in a due process hearing. Yes, you can. But be aware that if a due process hearing officer has already made a decision on an issue, and the same facts and parties are involved, the hearing officer's decision is final unless it is appealed. You may also wonder what happens if you file a written state complaint and request a due process hearing at the same time. If the issues are the same in both, the written state complaint resolution process will be postponed until after a due process hearing decision is made by the hearing officer. If the due process hearing officer includes the issue in the decision, the state education agency will not make a separate decision on the same issue. If the due process hearing officer does not make a decision on the issue, the state education agency must start or resume the written state complaint resolution process. Any issue in the written state complaint that is not in the request for a due process hearing must be resolved using the 60-day time limit, unless the state education agency extends the timeline. For additional information on written state complaints, including what happens after you file a complaint and how it compares to other dispute resolution options, visit www.cadreworks.org/parent-guides. For state-specific information or individual assistance, contact your state education agency or parent center. The Center for Parent Information and Resources can also assist. They provide information on a variety of special education topics and a current list of all the parent centers in the nation on their website, parentcenterhub.org. To review the Individuals with Disabilities Education Act, visit sites.ed.gov/IDEA. This concludes the IDEA Special Education Written State Complaints Parent Guide companion video. We encourage you to also view the What to Expect After a Written State Complaint is Filed video, as well as the other family resources located on CADRE's website, www.cadreworks.org/for-families.